Good morning, everyone. Good evening, good afternoon, depending on where you are in the world. Welcome back to Facebook Live with Joseph and Hall. We're excited today to talk to you about a lot of breaking news in the world of immigration. So let's get right into it. And I think let's start with you, Aaron. Why don't you talk to us about what's going on with ICE and the prosecutorial discretion memo?
Sure. So for a few of these updates, I've been saying, hey, we're expecting some new guidance soon. Well, we have some new guidance. It's guidance that goes to the part of ICE that's called OPLA, the Office of the Principal Legal Advisor. And those are the attorneys who serve as ICE prosecutors in immigration court. So what the guidance says is that they should consider exercising prosecutorial discretion in a lot of different circumstances. And I'm going to give some examples just to show people how broad this can be. So first of all, where somebody might qualify for an application outside of immigration court, they're encouraged to consider dismissing the case. So if you have a pending U visa, if you have the ability to apply for adjustment of status with USCIS, they really want ICE attorneys to consider dismissing the case to try to clear out the huge backlog. In addition, they are saying that they want ICE attorneys to consider dismissing cases where people are eligible for consular processing. That will get rid of removal proceedings and allow a lot of people to apply for a waiver before they leave the country and try to fix their status that way, away from the immigration courts. And for lots of other people, they are saying to consider agreeing to continuances or withdrawing appeals of immigration judges' grants. Taken all together, it's just very, very broad. And if you or somebody that you know is in removal proceedings, the world this week looks a lot different than it did 2 weeks ago. And so if you're a client here, you're going to want to have that conversation with your attorney. We'll be reaching out to you about this anyway. If you have another attorney, you want to make sure that you have a conversation with them about how this is going to change strategy for your case, because it's just a totally different world. One other specific piece of this is that a while back we had talked about a decision from the Supreme Court called Ms. Chavez. And Ms. Chavez said that when a government charging document called a notice to appear doesn't contain all the necessary information, it doesn't trigger the stop time rule, which is just something that blocks people from applying for cancellation of removal in removal proceedings. And for anybody who is impacted by a faulty or deficient NTA that triggered the stop time rule before Ms. Chavez, they are now saying that they're likely to join in motions to reopen if they're filed within 180 days. And that's just huge news, because motions to reopen are generally time barred once you get too far from the date of the decision. So if you have a removal order because you didn't qualify for this cancellation of removal because of the stop time rule, and you have a removal order that's old, you need to talk to an attorney like now to determine whether it makes sense to try to reopen your case and have a chance to stay here. That memo just came out this morning. We're still going through it and strategizing, but it is time for a lot of people who have removal orders or in removal proceedings to really talk with their attorneys and figure out how this changes their outlook.
And our firm will be conducting a firm-wide case review of all cases that we've represented in removal proceedings, and we'll be reaching out to our clients that could potentially benefit from a motion to reopen in these cases. You know, one of the things that's weird about the memo that came out today, Aaron, is that they limit it to 42B. But it seems to me that there's potential issues with 42A relief. There's a stop time rule in 42A as well. And it also seems to me that there's other issues aside from motions to reopen, like, for example, claims processing rules or jurisdictional rules. Like, you know, if the issue in the Supreme Court decision is that, you know, it is not a sufficient notice, then has jurisdiction ever vested in the court, or is there a claims processing issue? And maybe you could explain what that is.
Yeah, and this has been an issue that people have been raising since for a few years since the Supreme Court in Pereira, which first analyzed the stop time rule in this context. But Jeff's point is basically the statute says what an NTA is, and it has to include certain things. And one of those things is the time and date of the first hearing. And for as long as I've been practicing, it's almost never included. It just says to be set instead of giving you a time and place. And so once the Supreme Court said that those deficient documents are not really NTAs at all, a lot of people started saying, well, if they're not NTAs at all, then there's no charging document that's been filed. And this court doesn't have jurisdiction over me at all. And so, Judge, you should terminate this case. Now, when Pereira first came out a few years ago, a few immigration judges were actually terminating cases. And some federal judges in a different context were deciding that old orders were illegitimate because of this jurisdictional issue. Pretty quickly, the Board of Immigration Appeals stepped in and said, no, this is not a jurisdictional issue. And the judges still have the authority to conduct hearings under these documents. And while Ms. Chavez adds fuel to the fire for these arguments, it's certainly not a case that's based on jurisdiction. And so what the immigration courts, I'm 100% sure, are going to say in the Board of Immigration Appeals is that this changes nothing on those arguments. And I don't expect ICE to start joining in motions related to those arguments. Not to say they shouldn't be made in appropriate cases, but I just don't think that these prosecutorial discretion memos are going to take those arguments into account.
Got it. Anything that you have to add, Jennifer, on the PD memo or what we can look forward to in the future?
No.
Okay. All right. Well, if you have any questions about how the PD memo may implicate you in your case, please reach out to us. Make an appointment with one of us at the office. We're happy to talk about how it impacts you directly. The next thing we're going to talk about is a big Supreme Court case that came out this week that is also really bad. So, Jennifer, talk to us about the Supreme Court decision on TPS.
Sure. So on June 7th, there was a decision that came out in Sanchez v. Mayorkas. It was unanimous from the Supreme Court, written by Justice Kagan, that an individual who has temporary protected status, also called TPS, there's 12 countries that have TPS right now that are designated. An individual who has that, who entered the United States unlawfully, so without a visa, a valid visa, or like a tourist visa or something like that, is not eligible to become a lawful permanent resident through adjustment of status inside the United States. Before the Supreme Court decision, there were split circuits on this issue, and there were some circuits like the 10th that hadn't made a decision one way or the other. But now that the decision has come out from the Supreme Court, it affects all circuits, all states, districts in the United States. So what this means is that for someone right now who has temporary protected status to be able to adjust their status in the United States to lawful permanent residence, they would have either had to enter with a valid visa of some kind, or there's still the argument that entering on advanced parole might work. Now, there's a caveat to that, too, because this is different from the Supreme Court decision, but U.S. Citizenship and Immigration Services, USCIS, put out a memo back in August 2020 that after that decision, so after August 20th, 2020, people who enter on advanced parole with temporary protected status cannot apply for adjustment in front of USCIS. This doesn't apply necessarily in front of the courts yet. That's going to depend on the court and on the circuit that they're in. So it's really big because it means that before, where in some circuits, people with temporary protected status who were able to try to get green cards through that TPS as an admission aren't going to be able to do that anymore. And so it affects a lot of people.
So given that this idea of traveling on parole, right? Because if the initial entry was illegal, but then you get parole and leave the country and come back in on parole, technically it's a legal entry. Are you going to be, since the Supreme Court doesn't address that issue, is our office still going to be filing those cases for entrance on advanced parole?
As far as I'm aware, yes. My plan is.
And why would we do something when the law is unsettled, Aaron? Why would we file a case like that when the law is unsettled? Or Jennifer, either of you.
I mean, I can answer a couple of reasons. One is there's a shot that it'll work. And so you'll get your residents through that. Also, we can preserve issues for litigation.
That's right.
Yeah.
Anything to add to that, Aaron?
No, that's right. I mean, the position that came out with the USCIS adopting an AAO decision saying that advanced parole does not give you either a parole or admission sufficient to give adjustment of status is just nonsense. Mm-hmm. And so it needs to be challenged. And the only way to challenge it is by filing the cases and fighting them. And so absolutely, we're willing to do that. And when we do things like that, we always have frank conversations with our clients about, the obstacles that are in the way and the challenges we need to overcome. But it has to be done. And we're certainly willing and excited to do it.
Awesome. All right. Well, the last thing that we wanted to talk about today before we get into questions and answers is the International Entrepreneur Program. And this is a really interesting program because it was created in 2017 under the Trump administration to promote innovation and economic growth. And then when the Trump administration came into power, they rescinded the notice of proposed rulemaking. So, the rule that had been proposed by the Obama administration was, immediately rescinded. So the IEP program sort of went away. Then in the Biden administration on May 11th, the Biden administration withdrew the Trump rule that withdrew the Obama rule. So now the International Entrepreneur Program is reactivated under the Biden administration. And this is really good news for people abroad who want to start businesses or startups in the country. So what does it do? Well, first of all, it creates the ability to be paroled into the country, what we've been talking about, right? Parole into the country is a legal entry. Now, it's different from an admission. It's not considered a legal admission into the country, but the parole does give you the authority to change status or do other things once you enter the country. The requirements for parole are set out at 212.19 of the federal regulations. And to get the individual International Entrepreneur Program, you have to show, number one, that what you're going to do is going to create a substantial public benefit and that you have the potential for rapid business growth and job creation. So substantial ownership in the interest has to have been created in the past 5 years. So it has to be a fairly new startup and the ownership has to be created in the past 5 years. And you have to have a central and active role in the management of the enterprise. You can't be an actual employee. You have to actually have an active role in the enterprise. You have to show that the business has a substantial potential for rapid growth creation, job creation, and that the entity received at least $250,000 from qualified investors or startup awards and grants of at least $100,000. So there's really two ways to meet the standard, either individual investment of $250,000 or startup awards and grants of $100,000, or that you can partially meet either of those two things and also show substantial likelihood of job creation. And then finally, you have to show that you deserve it as a matter of discretion. The procedure is to file a form I-941 with a $1,200 filing fee and $85 biometrics fee with all the supporting documentation. Up to 3 entrepreneurs per enterprise per startup may qualify, plus their spouses and children. And the spouses of the individual investor can obtain work authorization into the country that's unrestricted. It allows the spouse to work wherever. The parole will last for up to 2.5 years and can be extended for an additional 2.5 years for up to 5 years. But here's the key part. There's no path to LPR citizenship. Now, that doesn't mean that once you create the business, there may be other opportunities through the business. But as far as the actual parole goes, it's really just to come into the country and create a startup. So a couple of the things we don't know about, right? So you pay this biometrics fee, for example, but you're outside the country. And at the present time, the Department of State has no mechanisms for taking biometrics abroad. So it's not clear at all how biometrics will be handled if you're outside to the United States. Another thing is that there are two other programs that are similar to this. There's the E2 investor program. That program requires that we have a treaty of commerce with the foreign country, and not every country has a treaty of commerce. So not every country qualifies for the E2. But more importantly, in order to get an E2, there has to be an actual influx of money from the foreign country. So the business itself has to be foreign owned, at least 51% foreign owned. And so, you know, that is left to be seen. So if you don't qualify for the E2, it could be that you still qualify for the IEP. We don't know processing times on this. As far as I know, I don't even know anyone that's filed one of these yet. But the government is actively promoting this program. They're having listening sessions to the general public to talk about the program. So they are fully capable and ready to accept these applications. So if you think that this may be something that you would benefit from, please contact our office and make an appointment for a consultation, because we'd love to help you with the IEP program. Before we go to questions, anything else from the two of you? Any other hot topics that we want to discuss?
I don't think so.
All right.
Get to it.
Let's go to some questions. All right. Let's start with, start at the top here. The first question has to do with Go and the new case called Good Luck that was also filed in the District of DC. And in that motion, in that filing, there was a notice of related case to the Go. So the question here is, how can Curtis, the attorney on that case, make a third motion, a third complaint for DV 2021 in DC, since he's already filed two other cases in the Northern District of California, one of which is a class action?
Yeah, I can take that. So I would just say that I think they actually had a hearing on the Rye case today. Which is
2 o'clock, I believe. I think it's at 2 o'clock Eastern. Actually, it started
maybe ongoing. So that's exciting for them. I would just say that you know, no class has been certified yet, and so there's no class yet, and I'm sure Curtis and his team are dealing with how to represent the people in the different cases. As I always say, they and their team have gotten a lot of great results for their plaintiffs, and that's awesome. And we wish them the best. And we will continue to represent the interests of our plaintiffs to the best we can without any compromise. And I know they'll do the same. So that's about all I can give on that.
Yeah, right now, all that has happened is with the complaint, Curtis Morrison has filed a notice of related action, right? So he's put the court on notice that their case is similar to ours. The case has been assigned to Judge Mehta, so we do have the same judge for both cases, but as of now, it has not been consolidated with Go. In order for that to happen, the court either has to indicate that they're going to consolidate and give us an opportunity to submit motions that we object, or Curtis has to file a motion to consolidate, which we would have the opportunity to object to. We fully intend on objecting to consolidation, mainly because we fully briefed the case and we are ready for oral argument. And so we would not want anything that would delay quick resolution of our case, especially that now that we know that our hearing's in July, and that gives us 2 months till September 30th to really resolve this issue. So we will aggressively object to consolidation. Okay. This is another Go question, Aaron. Any idea about adjudication of cases? Are we seeing any movement of Go plaintiffs? And do you have any idea?
We have seen some people get scheduled for interviews, and that's great news. Still not happening nearly fast enough, and there are still many consulates who are telling people we're not even considering doing DV 2021 cases, which is unacceptable. So yes, we're getting some people set for interviews and adjudications, and then too many people where we're going to need a court order to make it happen.
So Department of State has published that they've processed about 5,000 DV cases since the beginning of the year, which is pathetic. It's 10% of the overall number, and we're well over halfway through the year. So, you know, the actual process that DOS is engaging in is useless. It's not helpful. They've publicly said that DV is the lowest priority, and that some consulates have actually said they're not processing DV cases. So we're in very good position to show the harms to plaintiffs and the fact that the government's really not willing to have any plan to deal with this. So we'll keep you posted. All right, now we can switch to a Milligan or even a Rio case, because we have a case pending in Rio as well. So Rio K1s, any update on this? I can tell you that we've had in the past week 2 Rio K1 Milligan plaintiffs approved. I don't know where we are with the actual Rio, the Penn case, which is the Rio mandamus. You know, I can tell you sort of generally that we don't anticipate, with these consulate specific cases that we filed in the various consulates, we don't anticipate that we're going to have movement immediately. What's going to happen is the government's going to submit a motion to dismiss about 60 days after we filed the complaint, and we will respond to that. And, you know, if we win the motion to dismiss, it's possible then that the government will come back to the table knowing that the case is going to go to litigation and that they may be in a better posture to settle at that point. But really, I don't anticipate you're going to see much movement on your cases until we go through this motion to dismiss process. So if we do hear anything, we will let you know. Yes, Gus, we did. I did see the email today from Montreal and the lost, I think it was the lost police certificate or something, and the lack of organization. I'm okay with lack of organization as long as they schedule you and give you your visa, because you've waited long enough. So good luck to you, and I hope you all get some good news for us soon. All right, what about DV 2021? Well, that's why we filed the Go case. So if you're not in the Go case, if you are not a plaintiff in the Go case, you need to get in a case. You're not going to get your DV numbers unless you get in some sort of a mandamus lawsuit. So if you can't join the Go case, file an individual DV mandamus if you want to have any chance of retaining one of those numbers. All right, let's see. All right, here's a good one. This person just listened to the Rye argument on DV 2021. The government said that once a selected number is current, KCC would schedule appointments based on availability of consulates. But when my consulate reached out to KCC to find out, KCC says they're prioritizing low case numbers. Yeah, this is exactly the problem. You know, why this is a problem is that low case numbers don't matter. Everybody's current. And so, you know, if you're current, you have the ability to file regardless of your number. So, you know, in my opinion, this is just legally wrong, and we'll have to point this out to the judge.
The other thing is they're saying different things in different forums. So they say to people in response to email inquiries that we've seen from our plaintiffs, they'll say, well, your case number is not low enough. We're working on lower case numbers right now. And then they say in court that once a number is current, then it's just about appointment availability. It doesn't matter the case number. And so, you know, they have no consistency here, which is what we pointed out to the court, is that they say there's a line and that plaintiffs are trying to jump the line, but there is no line. I mean, it's total chaos. So Brandon, thanks for pointing that out. That's Brandon Go, the lead named plaintiff in Go. So thank you, Brandon.
Here's another one. This is more procedural. So we throw around a lot of words like class action and summary judgment and everything. And I know that we don't often explain what those things are. So this is a good procedural question. If one lawyer has a class action suit and a mandamus lawsuit on a DV case, can the judge in the mandamus case decide to wait for a ruling on the class action? And if yes, can a judge in a different mandamus case filed by different lawyers also decide to wait for the class action ruling?
These judges can do what they want, is the short answer. So yes, a judge can say, I want to see what happens in another case in a different district. They don't have to. When a case is ripe for a decision, it's been briefed and they have all the facts, they can make the decision. Given the urgency of the ruling that we need, we have been and will continue to make sure that Judge Mehta understands that there's no time to wait for other courts to do anything. We need a decision for our plaintiffs as soon as possible at the July 13th hearing. And the good thing about being with Judge Mehta is he gets that. He just handled this case in Gomez for 2020, and he fully understands it.
Yep. All right. What about the Kinsley case? So the Kinsley case is the challenge that we filed to the proclamations, the regional travel bans. Any idea what the status is on Kinsley?
I think summary judgment is going to be filed today or tomorrow. Is that right, Jeff?
Today's the 11th. Tomorrow, the 11th. It's going to be filed on the 11th. So,
but it's ready and it's looking really strong. So,
yeah, it's probably one of the best, in my opinion, one of the best pieces of writing our office has ever produced. It is really solid, bulletproof. It's like I call it death by a million cuts, because every single paragraph is going to bring blood from the government. It is just really well done. I don't see how we lose on this issue. We are filing it as a motion for preliminary injunction and or summary judgment. Ideally, we want the judge just to grant us summary judgment and rule in our favor. Preliminary injunction is a higher standard, but if we show the harm, then it allows the judge to give us interim relief or a Band-Aid relief while we wait for the ultimate decision. So we don't have too much of a concern about which the judge grants, although summary judgment would be a final decision. That is all briefing and arguments will be completed in that case by July 18th. So we should have a decision shortly after July 18th on Kinsley. Okay, we were told that the government assigned an attorney to Cairo's spouse's suit. However, the PACER doesn't show any government attorney name. Why is that? That's because we reached out to the government to find out who was assigned to the case, but the government has not entered their appearance on the case. So they haven't entered anything. They probably won't until they file the motion to dismiss, but we are in communication with them. So that's why we know who the attorney is. All right, another one. Why does the Moscow case show only a 30-day response time from the government instead of the normal 60 days? Is there a specific reason for the expedite, or is it just a typo on PACER? I don't know the answer to that. I haven't actually seen the PACER entry on that, so I don't know the answer to that. You're correct. The rule is 60 days. So if it does say 30 days, I think that's in error. So. All right. Why is KCC going so slow and not responding to emails for at least a month? Neither the embassy in Nepal is open nor KCC is responding. Anything you can do?
Anything that can be done about that? Not beyond, in my opinion, it's just about continuing to keep good records of all the good faith attempts that you're making to communicate both with the the embassy and with KCC. For our Go plaintiffs who are doing that, we're including their correspondence in court filings because part of what we are trying to do is show an unreasonable delay and that they're not acting in good faith and that they have no plan to administer this program. And what better evidence is there that they are doing that than total unresponsiveness to applicants' inquiries. The other thing is that they say that they are not adjudicating some applications because they're not documentarily qualified at KCC, when actually, DV 2021 people have sent their documents to KCC months ago, sometimes 6 months ago, and just haven't gotten a response yet. So it's Department of State's fault. They're not documentarily qualified, not the applicant's fault. So that's a long way of saying, keep at it. I know you're dejected, but that's the only thing you can do.
Yeah. All right. Anything else from you all before we wrap up this session of Facebook Live? All right. Well, all of you out there, thank you for your patience. We know that this is really hard for you, and being away from your loved ones, your employers, your families. I know it's really tough, and just know that we are fighting every single day for you, and we will continue to do so. So Thank you all for your attention, and we will see you next week at the same time on the same channel.
Wow.
Have a great weekend. Bye-bye.